Hi, this is chapter 8, Ethic, Law, and E-Commerce. In this chapter, we're going to study e-commerce, ethic and social and political issue. And then we're going to study the privacy related concept. Also, we're going to study the intellectual property. And then we're going to study the taxation of e-commerce and e-business. Also, we're going to study major public safety and welfare issue raised by e-commerce. The right to be forgotten, Europe lead on internet privacy. In June 2014, Google was the first to begin removing certain search engine query results in Europe after a ruling by the Court of Justice of the European Union. Europe's highest court, the ruling gave individuals the right to request that certain links to personal information found through a search of their name be removed. Class discussion: is Google responsible for the accuracy of link to other information? Why or why not? Why do European and American views on privacy protection differ so dramatically? How can the different perspectives on privacy be managed in a global environment like the internet? We're gonna talk about in our classroom. Understanding ethical, social, and political issues in e-commerce. Internet, like other technology, can enable new crime, affect environment, threaten social values. Cost and benefit must be carefully considered, especially when there are no clear-cut legal or cultural guidelines. Determining how or whether personal information should be retained or deleted on the internet is just one of many ethical, social, and political issues raised by the rapid evolution of the internet and e-commerce. The internet and its use in e-commerce have raised pervasive ethical, social, and political issues on a scale unprecedented for computer technology. A model for organized issue. Issues raised by internet and e-commerce can be viewed at individual, social, and political level. For major category of issue: information right, property right, governance, and then public safety and welfare. So information right: what right to their own personal information do individuals have in a public marketplace or in their private homes when internet technology make information collection so pervasive and efficient? What right do individuals have to access information about business firms and other organizations? Property right: how can traditional intellectual property right be enforced in an internet world where perfect copy of protected works can be made and easily distributed worldwide in seconds? Governance: should the internet and e-commerce be subject to public laws, and if so, what lawmaking body have jurisdiction, state, federal, and all international? Public safety and welfare: what efforts should be undertaken to ensure equitable access to the internet and e-commerce channel should the government be responsible for ensure that schools and colleges have access to the internet? Are certain online contents and activities such as fake news, pornography, gambling, or anonymous tweeting of hateful language a threat to public safety and welfare? What about connected car? Should mobile commerce be allowed from moving vehicles? Figure 8.1. The moral dimension of an internet society. The introduction of internet and e-commerce impact individual, society, and political institution. This fact, in fact, can be classified into four moral dimensions: property right, information right, governance, and public safety and welfare. Basic ethical concept. Ethic, study of principle used to determine right and wrong courses of action. Responsibility means that as free moral agent, individual, organization, and society are responsible for the action they take. Accountability means that individual, organization, and society should be held accountable to others for the consequences of their action. The third principle, liability, extends the concept of responsibility and accountability to the area of law. Liability is a feature of political system in which a body of law is in place that permit individuals to recover the damages done to them by other actors, system, or organization. Due process is a feature of law-governed society and refers to a process in which laws are known and understood, and there is an ability to appeal to higher authority to ensure that the laws have been correctly applied. Analyzing ethical dilemma. Ethical, social, and political controversy usually present themselves as dilemma. A dilemma is a situation in which there are at least two diametrically opposed actions, each of which support a desirable outcome. First, identify and clearly describe the fact. Second, define the conflict of dilemma and identify the higher order values involved. Third, identify the stakeholders. Fourth, identify the options that you can reasonably take. Fifth, identify the potential consequences of your option. Candidate ethical principle. First one is golden rule. Second one is universalism. Third one, slippery slope. First one, collective utilitarian principle. First one, risk aversion. Sixth one, no free lunch. Seventh one, the New York Times test. Eighth one, the social contract rule. The golden rule: do unto others as you would have them do unto you. Bring yourself into the place of others and thinking of yourself as the object of the decision can help you think about fairness in decision making. Universalism: If an action is not right for all situations, then it is not right for any specific situation. Immanuel Kant categorical imperative. Ask yourself, if we adopted this rule in every case, could the organization or society survive? Slippery slope. If an action cannot be taken repeatedly, then it is not right to take at all. An action may appear to work in one instance to solve a problem, but if repeated, would result in a negative outcome. In plain English, this rule can be stated as once started down a slippery path, you may not be able to stop. Collective utilitarian principle. Take the action that achieves the greater value for all of society. This rule assumes you can prioritize values in a rank order and understand the consequences of various courses of action. Risk aversion. Take the action that produces the least harm or the least potential cost. Some actions have extremely high failure cost of very low probability. Example, building a nuclear generating facility in an urban area, or extremely high failure cost of moderate probability, speeding an automobile accident. Avoid the high failure cost action and choose those actions whose consequences would not be catastrophic even if there were a failure. No free lunch. Assume that virtually all tangible and intangible objects are owned by someone else unless there is a specific declaration otherwise. If something someone else has created is useful to you, it has value, and you should assume the creator wants compensation for this work. The New York Times test for fact information law. Assume that the result of your decision on a matter will be the subject of the read article in the New York Times the next day. Will the reaction of readers be positive or negative? Will your parents, friends, and children be proud of your decision? Most criminal and unethical actors assume imperfect information, and therefore they assume their decision and the action will never be revealed. When making decisions involving ethical dilemma, it is wise to assume perfect information market. The social contract rule. Would you like to live in a society where the principle you are supporting would become an organizing principle of the entire society? For instance, you might think it is wonderful to download illegal copies of a Hollywood movie, but you might not want to live in a society that does not respect property rights, such as your property right to the car in your driveway or your right to a term paper or original art. Privacy and information right. Privacy, moral right of individual to be left alone, free from surveillance or interference from other individuals, organizations, and state. Information privacy for premises, right to control information collected about them, right to be forgotten, right to know when information is collected, when give consent, informed consent, right to personal information due process, right to have personal information stored in a secure manner. Table 8.2, the FTC's Fair Information Practice Principle. So, notice awareness core principle, choice consent core principle, access participation, security, enforcement. Privacy in the public sector, privacy right of citizen. Public sector privacy right have long history. First Amendment, Fourth Amendment, 14th Amendment. When the first large-scale nationwide computerized system began to appear in the United States in the 1960s, privacy issue and claims laws, for instance, credit card system, for the first time gave a retail merchant and financial institution the ability to symmetrically collect digital information on consumer behavior. So constitutional implied privacy right did not cover collection and use of personal information. 1947 Privacy Act and federal and state law to protect individuals against unreasonable government intrusion. Privacy issue laws with the first large-scale nationwide computerized system, credit card system, credit rating agency, piecemeal federal and state privacy registration applying to specific industry. Spock versus Robbins. What harm must be shown in order to sue? Historically, few claims to privacy in public open markets such as in e-commerce. Emergence of internet has created an enormous collection of personal data, ideal environment for business and government to invade personal privacy of consumer, Google, Amazon, Netflix, etc. Information collected by website. Data collected include personal identifiable information, anonymous information, types of data collected, name, address, phone number, email address, social security number, bank and credit account, gender, age, occupation, education level, preference data, transaction data, clickstream data, browser type, difference. Key issues in online privacy of consumer. Top concern, profiling and advertising targeting. Social network privacy. Sharing of information by marketers and mobile phone privacy. And digital assistant privacy. So in recently for 90% of Americans are concerned about their online privacy and 91% believes they have lost control over their online information. Marketing, profiling, behavioral targeting, and retargeting. Profiling, creation of data images that characterize online individuals and group behavior. Anonymous profiles, personal profile, facial recognition, a new dimension. Advertising network, track consumer and browsing behavior on web. dynamically adjust what user sees on screen. Will then refresh profiles of consumer. Google's new privacy policy. Business perspective increases effectiveness of advertising subsidized content. Enable sensing of demand for new product. Critics' perspectives undermines expectation of anonymity and privacy. Enable price discrimination. Social network, privacy and self-revelation. Social network encourages sharing personal detail, force unique challenges to maintaining privacy. Facebook massive database, serving advertise to users not on Facebook, sharing information with third party, personal control over personal information versus organizations' desire to monetize social network. Mobile devices, privacy issue, mobile application, funnel personal information to mobile advertisers for targeting advertisement. Track and store user location, track users' use of other application, persistent location tracking. United States Supreme Court rules that police need warrant prior to searching a cell phone for information. Consumer Privacy Regulation, the FTC. Fair Information Practice Principle. In the United States, the FTC has taken the lead in conducting research on online privacy, recommending legislation to Congress and enforcing privacy regulation. Informed consent, opt-in, and opt-out. The concept of informed consent defined as consent given with knowledge of all material facts needed to make a rational decision. The opt-in model requires an affirmative action by the consumer to allow collection and use of information. For instance, using opt-in, consumer would first be asked if they approved of the collection and use of information, and then directed to check a selection box if they agree. Otherwise, the default is not to approve the collection of data. In the opt-out model, the default is to collect information unless the consumer takes an affirmative action to prevent the collection of data by checking a box or by filling out a form. In the United States, the most e-commerce company that offer informed consent use the opt-out model. Unless the consumer check a box to specifically decline, information is collected. Often the selection box is at the very bottom of the web page where the consumer is unlikely to see it, or located within complex menu. Harm-based approach. Do not track mechanism. Recent emphasis is to give consumer rights regarding collected personal information. FTC Currency Privacy Framework scope applies to all commercial entities, that collect or use consumer data, not limited to those that just collect personal identifiable information. Privacy by design. Companies should promote consumer privacy throughout the organization and at every stage of development of product and service. Data security, reasonable collection limit, reasonable and appropriate data retention policy, data accuracy, comprehensive data management procedure. Simplified choice. Companies should simplify consumer choice, need not provide choice before collecting and using data for commonly accepted practices. Product and fulfillment, internal operation, fraud prevention, legal compliance, first-party marketing, greater transparency, increased transparency of data practice by making privacy notice clearer, providing consumer with reasonable access to data about themselves, providing prominent disclosures, and obtaining express affirmative consent, educating consumer about commercial data privacy practices. Consumer Privacy Regulation, the Federal Communication Commission. Year 2015 classification of broadband ISP as similar to public utility services and subject to FCC regulation. Year 2016, FCC approved the new privacy rules for broadband ISPs must notify user of privacy information or obtain user consent to collect information. Service cannot be contingent on users surrendering privacy. Year 2017, Congress voted to repeal privacy rule for broadband ISPs. Privacy policy. Website terminology of use notices. As noted previously, one conceptual basis of American privacy law is notification and consent. It is assumed that consumers can read terminology of use notice or privacy policies concerning how a website will use their personal information and then make a rational choice to either consent to the terminology of use, opt out of the data collection, if there is an option, or stop using the site. Recent studies showed this policy would take average reader 8 hours to read policy, have conflicting statement, little oversight, and comparison between policies of different companies. Privacy protection in Europe. European privacy protection much stronger than in United States. Year 2016 General Data Protection Regulation replaces Data Protection Directive of 1998, applied to all organizations that operate in EU, protect wide variety of personal identifiable information, strengthens citizens' right to their own personal data, strengthens oversight of firms to ensure compliance. Environment has turned against the United States firms like Facebook and unfettered collection and use of personal data. Industry self-regulation. Privacy Seal Program. Network Advertising Initiative. Advertising Choices Program. In general, self-regulation has not succeeded in reducing American fear of privacy invasion or reducing the rebel of privacy invasion. Federal and state government regulation alone is insufficient to protect consumer privacy. The technology evolves quickly and provides marketers more tools to collect and use consumer private information before legislatures and government agencies can respond. Technology solution. Solutions include intelligent tracking protection, differential privacy software, privacy default browser, message encryption, spyware blocker, pop-up blocker and ad blocker, secure email, anonymous remailer, cookie manager, public key encryption. A number of technology solutions have been developed to deal with the invasion of privacy on the web and mobile platform. Privacy protection. Privacy protection as a business, personal data economy, Internet of Me, right management tool, privacy advocacy group. As the website has become more invasive and aggressive in their use of personal information in the last 5 years, public concern has grown and a small number of startup firms have sprung up that enable users to reclaiming control over their personal information and monetize their information by selling it to third-party firms, mostly advertising firms. Personal data economy, the Internet of Me and Life management tool. These ideas have several names. The idea of an individual claiming ownership of their personal data, depositing it in a trusted data store, and then selling that information to third parties is not now, but with the development of supportive digital technology, it can be considered today a technically feasible approach to some contemporary privacy issues such as control over personal information and transparency. Limitation on the right to privacy. We've emphasized that the privacy in the public sector, freedom from government restriction and search is very different from privacy in the private consumer market sector, but increasingly these different realms of personal information are coming together. Law enforcement and surveillance, Edward Snowden and NSA PRISM program, legislation that strengthens ability of law enforcement to monitor internet users without their knowledge. Clear USA Patriot Act, Cybersecurity Enforcement Act, Homeland Security Act, USA PRISM. In 2013, Edward Snowden, a security contractor for the United States National Security Agency, NSA, began to release NSA document to The Guardian, a United Kingdom newspaper, providing a detailed description of NSA surveillance program of both United States and foreign citizens. This program was unprecedented in scope and involved wholesale collection of cell phone metadata around the world, tapping communication lines of Google, Yahoo, and other internet service, and tapping cellular phone of foreign readers. The program did not target United States citizens. The NSA enlisted the support of the major telecommunication carrier to give it information about American phone calls and email in a program called PRISM. This program was conceived in the aftermath of the terrorist attack on the United States on September 11, 2001, and were envisaged as necessary to protect the country. Apple's iPhone 6 and encryption controversy. It's rare, in fact unprecedented, that an internet giant would take a public stand to support the privacy of individuals from government surveillance and then back it up by making it impossible for law enforcement agencies hunting criminals and terrorists to gain access to the personal information of this person. Supreme Court case limiting law enforcement ability to obtain data from mobile phone without a warrant. Liley versus California, United States versus Jones. Use of personal data by government agency is widespread. Taking matter into own hands in 2014, Apple introduced the iPhone 6, which offered the ability to encrypt email, photos, and contact stored on the phone using a strong end-to-end encryption algorithm designed to prevent third party from reading the message while in transit. Insight on technology, Apple defender of privacy, class discussion. Are there circumstances that warrant the invasion of personal digital information and property? In the All Writ Act of 1789 applicable to today's technology-driven privacy issue? Should citizens charged with a crime or convicted criminal have any right to privacy? How does Apple's views on privacy differ from those of Facebook's and Google? We're going to talk about in our classroom. Intellectual property right. Congress shall have the power to promote the progress of science and useful art by securing for limited time to author and inventor the exclusive right to their respective writing and discovery. Next to privacy, the most controversial ethics, social, and political issue related to e-commerce is the fate of intellectual property right. Intellectual property, all tangible and intangible product of a human mind. Major ethical issue, how should we treat property that belongs to others? Major social issue, is there continued value in protecting intellectual property in the internet age? Major political issue, how can internet and e-commerce be regulated or governed to protect intellectual property. Intellectual property protection. Main types of protection: copyright, patent, trademark law, trade secret law. In the United States, copyright protect original forms of expression such as writing, books, periodicals, lecture note, art, drawings, photograph, music, motion picture, performance, and computer program from being copied by others for a period of time. Up until 1998, the copyright law protected work of individuals for their lifetime plus 50 years beyond their life, and work created for hire and owned by corporations such as Mickey Mouse of the Disney Corporation for 75 years after initial creation. Copyright does not protect ideas, just their expression in a tangible medium such as a paper, cassette tape, or handwriting note. In 1998, Congress extended the period of the copyright protection for an additional 20 years, for a total 95 years for copyright-owned work, and right plus 7 years of protection for work created by individuals. Patent. Trademark law, trade secret law. Goal of intellectual property law: balance two competing interests, public and private. Maintaining this balance of interest is always challenged by the invention of new technology. Copyright protects original form of expression, not ideas from being copied by others for a period of time. Fair use of doctrine. So under certain circumstances, permit use of copyrighted material without permission. Digital Millennium Copyright Act of 1998, first major effort to adjust copyright law to internet age, implement WIPO treaty that makes it illegal to make, distribute, or use devices that circumvent technology-based protection of copyrighted material, safe harbor provision. Patent. Grant owner 20-year monopoly on idea behind an invention. Invention must be new, non-obvious, novel, encourages inventor, promote dissemination of new techniques through licensing. Stifles competition by raising barriers to entry. E-commerce patent. 1998 State Street Bank and Trust versus Signature Financial Group. Business method patent. 2014 Alice Corporation lawsuit. Supreme Court rules that software does not make a basic business method or abstract idea patentable. E-commerce patent. Amazon one-click purchasing. Akamai Internet Contents Delivery Global Hosting System. Trademark. Identify distinguished goods and indicate their sources. Purpose: ensure consumer get what is paid for, expected to receive, protect owner against privacy and misappropriation, infringement, dilution, Federal Trademark Dilution Act and Trademark Dilution Revision Act, Uniform Rapid Suspension System, dilution, any behavior that would weaken the connection between the trademark and the product. Trademark and internet, cyber courting and brand jacking, Anti-Cyber Courting Consumer Protection Act, cyber piracy, type courting, meta tagging, keywording, linking and deep linking, framing. Anti-Cyber Courting Consumer Protection Act creates civil liability for anyone who attempts in bad faith to profit from an existing famous or distinctive trademark by registering an internet domain name that is identical or confusingly similar to or dilutive of that trademark. Cyberquoting involves the registration of an infringing domain name or other internet use of an existing trademark for the purpose of extorting payment from the legitimate owner. Cyber piracy involves the same behavior as cyberquoting, but with the intent of diverting traffic from the legitimate site to an infringing site. Meta tagging, the legal status of using famous or distinctive mark as meta tag is more complex and subtle. The use of trademark in meta tag is permitted if the use does not mislead or confuse consumer. Keywording, the permissibility of using trademark as keyword on search engine is also subtle and depends on the extent to which such use is considered to be a use in commerce and causes initial customer confusion and on the content of the search result. Linking refers to fielding hypertext link from one site to another site. This is obviously a major design feature and benefit of the web. Deep linking involves bypassing the target site homepage and going directly to a content page. Framing involves displaying the contents of another website inside your own website within a frame or window. The user never leaves the framer's site and can be exposed to advertising while the target site advertising is distorted or eliminated. Trade secret, much of the values created by the firm lies not in copyright, patent, or even trademark. There is kind of intellectual property that has to do with business, procedure, formula, and method of manufacture and service delivery, from which the firm derives value and which it does not want to share with others in the form of patent application or copyright application. Business procedure, formula, method of manufacture, and service delivery may not be equal or novel. Trade secrets are secret, have commercial value to owner. Owner has taken steps to protect. 2016 Defense Trade Secret Act. Who govern the internet and e-commerce? Mixed mode environment, self-regulation through variety of internet policy and technical bodies, coexistence with limited government regulation. ICANN domain name system. Internet can be easily controlled, monitored, and regulated from a central location. Taxation, non-local nature of internet commerce, complicate governance and jurisdiction issues. Sales tax, government in Europe and United States rely on sales tax. As e-commerce grew, states began to argue their inability to tax remote e-commerce sales was siphoning away billions of tax dollars. Supreme Court ruled in South Dakota versus Wayfair that state could tax online sales even when seller did not have physical location in the state. Internet Tax Freedom Act. Insight on business, new rules extend EU taxation of e-commerce. Most people are happy when they discover they don't have to pay any sales tax on a purchase they make online. However, few stop to consider the implication that this may have. Class discussion. Given the nature of the internet, should sales tax be based on the location of the consumer rather than the seller? Why is there is a struggle to define the nature of small business? How big do you think of small business is? What is the approach the EU has taken with respect to tax revenue from e-business? Net neutrality. All internet activity charges the same rate regardless of the bandwidth used. Netflix and YouTube together consume about 50% of bandwidth in United States. Prior to 2015, internet service provider could throttle high volume user. February 2015, FCC ruled that broadband internet service providers should be viewed and regulated as public utility. Under Trump administration, net neutrality regulations have been repealed, but many states attempt to reinstate them via state law and regulation. Public safety and welfare. Protection of children against pornography and privacy infringement. Passing registration that will survive court challenges have proved difficult. Effort to control gambling and restrict sales of drugs and cigarettes. Prevent all cigarette trafficking act. Unlawful internet gambling enforcement act. Increase in number of states allowing online gambling. Insight on society. The internet drug bazaar extends around the globe. In August 2017, Interpol announced the result of a 10th annual Operation Panji effort to combat sales of illegal drugs online. The operation involves the regulatory agency of 123 different countries, shut down almost 3,500 websites, and resulted in the arrest of 393 people and the seizure of 25 million doses of illegal drugs worth 51 million. Class discussion. What's wrong with buying prescription drug online, especially if the prices are lower? What are the risks and benefits of online pharmacies? Should online pharmacy require a physician's prescription? How do online pharmacies challenge the traditional business model of pharmacies and drug firm? What are the challenges in regulating online pharmacy? Who benefits and who lose from online pharmacies? We're gonna talk about in our class. Careers in e-commerce. Actually, there are several e-commerce privacy research associate position. So you have to prepare the qualification and skills and then interview. See you later. Have a great day. Bye.